Hey guys, let's talk about this Darrell Brooks appeal again. There were some comments made that made me consider that there were some potential grounds for his appeal that ought to be addressed, not only for how they apply to his case, but just what the law is generally. The two most important of those, I think, relate to somebody's right to have an impartial jury. And in one aspect, the comments were brought up in the fact that his jury was all white. Everybody on it was all white. So, hey, take that up to the Court of Appeals. He doesn't have any black people on his jury. Give him another trial or let him go free. Is that really what the law is? We'll take a look at it. The second is change of venue. Hey, everybody heard of the parade massacre where it was. You got to move it to somewhere else. If you don't, let him walk free or give him a new trial. Is that really what the law is? And I'm going to touch again briefly, just quickly, on his self-representation thing. But consider that more than 90% of criminal appeals filed in Wisconsin fail. And the odds that Judge DARRELL looked at this stuff carefully and made a mistake are pretty low. But again, we'll look at what the law is, because these are sensible concerns that people have over whether you get an impartial jury or not. But first, let's cover some concepts of what is an appeal, because several people said, well, do these poor people have to testify again and that sort of thing? And no, an appeal is almost exclusively a paperwork-based exercise where you write to the Court of Appeals a brief that outlines your arguments for what were the material legal errors that occurred during the trial that you think warrant a reversal. What you can't do is go to the Court of Appeals and say, man, I can't believe the jury believed witness so-and-so. I mean, that person was probably a liar. Come on, Court of Appeals, you watch it yourself and see what you think. They don't go back and reweigh the factual contentions of the case. They're looking for legal errors. That's what they're doing. And they're doing it by paperwork. Now, there can be an oral argument. For example, in Wisconsin, the presumptive time period for an oral argument on a case is 30 minutes, and that occurs deep into the appeal. That may be by telephone, it may be in person, it may be live streamed in audio, it may be probably not live streamed on video. But the court can also just dispense with oral argument if it wants to for various reasons. There is no new evidence. The appeal is based on the trial record and the things that are considered record on appeal. They aren't calling people to testify or anything like that. And you get an appeal as of right. Darrell Brooks does get to appeal. He doesn't get a right to a successful appeal. I don't think that's going to happen here, but let's look at these instances that we're here to discuss. So you have a constitutional right to an impartial jury and to be tried in the district where the crime occurred. That's in the Sixth Amendment to the United States Constitution. So what does that mean? Does that mean if there's 10% Hispanics in an area that you got to have at least 1 out of 10 jurors be Hispanic, and you need to check the race of each type of group and make sure to check sexuality? And it doesn't mean that stuff. So for example, the state cannot, as a pretext or in reality, strike members of a jury for certain reasons, such as the color of their skin. You can't do that, or you're not supposed to do that. The Supreme Court has said that's a no-go. That's unconstitutional. But that does not mean, on the other hand, that the judge has to sit there and count each person in the jury. And if he can't quite tell how they identify, you have to ask them which race they are and make sure that you see exact percentages and things like that. That's not what the law is. So let's look at how the law is applied in Wisconsin to see whether the judge should have done something differently for the jury composition that she ended up with for Brooks' trial, which was reported to be all white. Let's look at a case of State versus Sanders in the Wisconsin Court of Appeals. The defendant there claimed an equal protection violation under the United States and Wisconsin constitutions because the state struck the only 2 African-American potential jurors. That was it. They didn't leave any on to the jury. And so the defendant said, hey, that's unfair, right? I didn't get anybody who was black on my jury. The court analyzed the case and said that is not a reversible error. There was no purposeful discrimination and therefore no equal protection violation. In these cases, those 2 jurors had answered in voir dire that they were less likely to believe a witness if they were police because of past police interactions they or somebody, a family member or something had, that they would be less likely to believe law enforcement. So a defendant who wants to claim this kind of discrimination, they have to show that the district attorney or the prosecuting attorney had a racially discriminatory intent or purpose. And to do it, there's a 3-step process the court is supposed to go through. First, the defendant makes what's called a prima facie showing that the peremptory challenges of the prosecution were race-based. And the peremptory challenge is when you can just stand up and say, Your Honor, we'd like to excuse so-and-so. We don't need to say why. Because the challenge for cause can be different. And that's the person's clearly biased or whatever. Maybe they know that the defendant's sister or something like that. The judge would throw them off. But you get peremptory challenges, and you can do those at your own election. So you show, hey, these are being exercised in a race-based manner. Every time there's a black person come up, the state just lets them go. And if you do that, then the DA has to come back and provide a race-neutral explanation. Then the court looks at the situation and determines if the defendant met the defendant's burden to show purposeful discrimination. And when it's on review at the Court of Appeals or higher, great deference is given to the circuit court decision because they're the ones there able to evaluate all the people in the courtroom, the demeanor and credibility of the people talking, including the prosecuting attorney and defense counsel. And the court in this case said, listen, bias against law enforcement is a legitimate and very understandable reason for the state to strike potential jurors, and that's regardless of race. The court also noted that 2 other jurors who were white were struck for being biased against police. So there was not established by the defendant that the state was specifically targeting black people to knock off the jury, even though the state, in fact, knocked the only 2 potential black jurors off of the jury. So you can see from that this is not a results-driven situation. Okay, this analysis proceeds forward from the intent of the prosecuting attorney. That doesn't look good for Brooks. Are you really telling me you saw this trial of Brooks and have anything on the record that indicates that the district attorney, the prosecuting attorney, was biased against people based on skin color, anything at all, other than potentially the results? I don't even know the races of the people who were struck. And for example, Brooks ended up striking 10 people, 2 of them on purpose and 8 by random because he refused to participate in the process. What color were those people? I don't know. Is he going to be able to show that the prosecution specifically targeted people based on race to get them off of the jury? There's no evidence of that. Plus, I doubt he properly sustained any kind of objection to that. If that gets overlooked by the Court of Appeals to evaluate this, I don't know. But the point is, it's a tough case to make. Let's look at another one, and that's State versus Lamont. In that case, there was 1 black person in the jury pool, and the state's attorney struck that person. So the only black person was struck out of the jury pool. Now, the defense counsel stood up and said, I would like to request a Batson hearing on this, and that's from Supreme Court precedent, and requested that the state's attorney provide a race-neutral reason for why this person is struck. And the state came back and said, listen, we've looked at this person's name and where they live, and there were general questions to the whole jury pool about whether they'd had contacts with police and then other things about police interactions and stuff. And based on their records, they think that in likelihood, he has had contact with police at his household, and he didn't answer that. But they didn't ask him that specifically. The reviewing court, the appellate court, says, listen, unless discriminatory intent is inherent in the district attorney's explanation, the reason offered will be deemed race neutral. So in this case, the state had some information that gave them some reason to not want this person. The reason doesn't even have to be a good reason or well-founded in fact, and the court upheld the jury selection. There was a case in Wisconsin where the state struck the only black juror, and when asked by the court, why did you do that? The state said, I don't know anything about him. Now, granted, when you select a jury, you do want to know about your jurors as much as you can, but guess what? That's part of what voir dire is for, so you can ask them questions, right? So that's generally how you do that. So the court in that case said, listen, it's one thing to have a good reason. It's one thing to have a bad reason that I disagree with, but it's still a reason. But it's another thing to have no reason. So you can't just have no reason, but there's no indication here that the state was striking people based on race or that it was requested that they explain why they were striking people of certain colors and couldn't come up with an explanation. I don't think any of that stuff happened. So the fact that there was a white jury is not in itself under the law, or an all-black jury for that matter, a reason to reverse a conviction. You have to show some discrimination going on in the jury selection process by the state's attorney. So let's switch it to the other reason why you might not have an impartial jury, and that is pretrial publicity. Hey, a lot of publicity about this parade massacre, right? Everybody there heard about it. Therefore, the judge didn't move it out of the county. Therefore, throw this case out and do it again somewhere else. Is that necessarily the conclusion? It's not so simple. And if it were that simple, why didn't the judge do it? Now, I'm not going to say the judge can't be wrong ever, but I am saying if you have a little soundbite in mind, pretrial publicity equals move trial, and you think that's just how easy it is, that's not really how it works. In fact, her order on this was well over an hour long, her order on it. just her telling them what her decision was. So it's quite a bit more complicated than pretrial publicity equals move trial. Now, it can be that easy. If the judge says, hey, I want to move the trial, and moves it, then that's what happens. But if they don't, there's an analysis that they had to have gone through if there is substantial pretrial publicity. And again, she did it. She spent a considerable amount of time on it. She allowed the state to argue. She allowed defense counsel to argue. That was before Brooks fired his counsel. And then she analyzed it herself, considered all kinds of information, and delivered her decision along with the process of how she would select an impartial jury. But just to frame your mind a little bit away from the soundbite of publicity equals move trial, let's consider some other trials that didn't get moved. World Trade Center bombings in New York City in '93, they were held where they occurred. The Boston bomber held where it occurred, despite that guy, I think, filing 4 motions to change venue and it getting considered at the Circuit Court of Appeals as well as the District Court, held where it occurred. The 9/11 attack for one of the defendants was held minutes away from the Pentagon. The Enron case was held at its headquarters. And relevant to this case, in Waukesha County, the Slender Man case was held there, as Judge DeRoe referenced in her order. And it had a lot of publicity because of how weird it was, and they didn't move it out of the county. Those are some significant cases that didn't move, so that might trigger in your mind, well, if those didn't move, then why would any move? Well, there's an analysis that goes on, and to some degree, it is up to the trial court to decide it based on the situation of the case and how they can manage it. And let's look at some of the factors. So the United States Supreme Court has held in some cases that a trial has to be moved. There was a pretty famous case where a person's confession was extracted from them without any of their rights being given and then played on TV over and over again, that the state had provided that. And the court said, no, that creates a kangaroo court atmosphere where the decision of his guilt is put out there in the media over and over and over again before he's tried. And we think it should have been moved for that reason. But things short of that, it gets a lot murkier. So the Supreme Court has said that, quote, pretrial publicity, even pervasive, adverse publicity, does not inevitably lead to an unfair trial. That's in Skilling versus U.S. That's the Enron case. Court has also said in Reynolds versus United States, every case of public interest is almost, as a matter of necessity, brought to the attention of all the intelligent people in the vicinity, and scarcely anyone can be found among those best fitted to be jurors who has not read or heard of it, and who has not some impression or some opinion in respect to its merits. That's the United States Supreme Court. At the Circuit Court of Appeals level, Sarnoff versus U.S., that's the Boston bomber case, the Federal Circuit Court of Appeals said, any high-profile case will receive significant media attention. It is no surprise that people in general, and especially the well-informed, will be aware of it. Knowledge, however, does not equate to disqualifying prejudice. Now, the Supreme Court has said that the trial court's finding of juror impartiality, even in the context of a change of venue, is due deference at its peak, its pinnacle. That's when you should most defer to the trial court. Now, that's for federal cases. Wisconsin dials that back a little bit. But I'm making the point here about you don't just get to walk free because they didn't move your case and it had been on TV a lot. Now, there was a case that went to the United States Supreme Court a long time ago that came out of Wisconsin where they had a statute that the Wisconsin Supreme Court said you cannot even apply for a change of venue no matter what the circumstances if it's just a misdemeanor. And the Supreme Court said, no, you can't do that. You got to at least be able to apply for it, right? And then have it considered under various factors. So that sets a little bit of a floor there. So let's head back to Wisconsin and look at some of their cases on this at the appellate level. In State versus Jacobus, the defendant complained that widespread publicity permeated the county where his trial was held. But jurors and voir dire said they would have an open mind and base their decision on the evidence, and any media exposure that they had would not stop them from reaching a fair and impartial verdict. The court said all would acknowledge the practical impossibility of coming up with a pristine panel when the case has lots of publicity, and that's not the standard. In State versus Massault, the Wisconsin Supreme Court said the law has long recognized that it is impossible to impanel a jury completely immune from prejudice and totally insulated from non-evidentiary information. And of course, Wisconsin statutes do provide that you can request a change of venue, and that if the court determines such prejudice exists that a fair trial cannot be had, then they should change the county of the trial or select jurors from a different county. And that's reviewed for erroneous exercise of discretion. So that court has to find that. Publicity does not equal move the trial. There's more to it than that. So, for example, in McKissick versus State in Wisconsin, the court said, here are some factors to look at or that you should look at when you're considering whether to move the trial or not. The inflammatory nature of the publicity. In other words, was it fact-based or unfairly targeting the defendant? So reporting on the massacre itself is just fact-based reporting. It's not inherently inflammatory. It's a terrible event that did occur. It's not whether it occurred, it did occur. It's just a question of who did it. So again, the United States Supreme Court, it said when they showed somebody's confession on TV over and over, that was prejudicial, especially because the confession wasn't lawful. If you had a lot of editorials maybe on TV just before the trial saying this guy's so guilty, he's got to go to jail, come on. But just reporting on the situation is not the highest level of problematic publicity at all. The degree to which it permeated the county or the potential jury pool, and of course that was a lot in this case. The timing and specificity of the publicity, and the court has held before that just waiting 11 months to 12 months after the event can let the spirit, the original spirit and anger and emotions die down to some degree, even if there had been a lot of publicity about the event or continuing publicity. The court also should evaluate the degree of care exercised in selecting a jury and what was possible and what the trial court did. And in the case of Judge DARRELL, she sent out a questionnaire to the jury pool. She had input from the defense and the state and asked over 100 questions. She then said she would have a questionnaire hearing where she would allow the defense counsel and state to strike any jurors for cause with no limit to the number of cause. So if somebody showed some kind of prejudice in answering the questions that I saw this or I believe this or whatever, you could just strike them out of the pool. So even before they show up, you're going to knock out the worst people. And she said that we'll have no time limit on impaneling the jury. So when we do get them in here, I'm not going to tell you only got 2 hours to ask questions or whatever. We'll take the time that it takes. And she also gave the attorneys additional peremptory challenges. So she gave them 4 challenges on top of the 6 they normally would get to say you can just strike somebody for no reason at all. So even if there's not cause, there's no bias or whatever that the person's exhibited, you just don't want them on the jury, I'll give you 10 of those. She also looked at the participation of the state in this and said, hey, was the state leaking out things to make this guy look bad? And she said, no, they sealed the search warrants. Other matters in the case had been sealed. The defense had not even alleged that the state had been trying to inflame passions against Brooks. She also looked at the severity of the defense, of course, which was quite high. But in all those contexts, she said, look, I can, through this questionnaire, weed out the people who already have intractable opinions or perhaps they feel like they've been exposed to enough negative things about Brooks that they can't be fair. We'll weed those out. Then I'm going to let you strike anybody that you can show me has a for-cause reason. And then when they come in here to be impaneled, we'll take all the time we need. And she said, I have no doubt that we will be able to impanel an impartial jury in this county.
In conclusion, the court of course, started by asking the following question. When does the publicity attending conduct charged as criminal dim prospects that the trier can judge a case as due process requires impartially, unswayed by outside influence? Given the facts presented in this case, the relevant statutes, constitutional provisions, and case law, it is clear to this court that a change of venue is not required. This court is committed to ensuring that the rights of Mr. Brooks to a fair trial and an impartial jury are protected. In this case, the defense has failed to demonstrate that there is a likelihood of community prejudice so pervasive as to preclude the possibility of a fair trial in Waukesha County. The defense has also not demonstrated actual bias or actual prejudice in this county. There is no doubt in the court's mind that an impartial jury can and will be impaneled in Waukesha County with the strong methods outlined today. For all of these reasons, the motion to change venue is hereby denied.
Let's take another look at a case, State versus Tucker at the Wisconsin Supreme Court. This was a case that Judge DARRELL quoted. So this guy shot a police officer, but the court noted the coverage was largely factual. Okay, they didn't run editorials saying, hang this guy, he's definitely guilty, throw the book at him. They talked about what did happen in the case. And there really wasn't an argument that he did the shooting. It's just why he did it and whether it was justified or he was coerced or whatever, but not so much that it happened. And note in this case, Brooks in his closing argument really didn't try to argue he wasn't the guy driving. He just kept harping on this wasn't intentional. You can't show it's intentional. And why don't you just throw this case out? And there really is no case that he wasn't the guy in the truck, right? If he had a case for lack of intention that his attorneys were trying to work on, well, he did a very terrible job of that during the trial, obviously. In the Tucker case, they waited 11 months, and the court noted that and said it's not like this trial happened right after the event. And the jurors in that case had seen media, but the fact they had seen media, the court said, is not enough to rebut the presumption of juror impartiality. To have obtained information of the matters at issue through newspapers, radio, or television is not cause for a challenge. That's what the court said, and Judge DeRoe quoted that as well. If you go up on appeal and say, Judge, there was a lot of publicity, so we just should throw this out and do it again somewhere else, that's not going to get it. You're going to have to show that the trial court failed pretty badly, erroneous exercise of discretion, not only in weighing how much publicity there was, but in how she selected the jury. So only a couple of brief comments again on this self-representation issue of Brooks, because it keeps coming up. And one is, it doesn't matter that he was bad at it. The court does not say, well, if he was bad at representing himself, then he can appeal for ineffective assistance of counsel. That's not going to work. Was he competent to choose to self-represent? And if he was competent to stand trial and he found he was, it's just a short bridge from that to whether he understands what's going on to self-represent himself. Even if a lot of that is in ignorance, he was told that there are things you don't understand. So he was apprised of that. You're not supposed to send him to law school and see if he passes the bar exam or not. You're just supposed to tell him there are a lot of risk here. You got trained members of the bar, know things there are things you don't even know you're missing. And he's like, no, I'm going to do it myself. So he made a knowing election to do it. So I don't think that goes anywhere either. The final point on that was his insistence that I'm not waiving my right to stand by counsel. And the court said that's not the law in Wisconsin. It's also not the law in Wisconsin. There can't be a standby counsel. The law in Wisconsin, as Judge DeRoe said, is that you would have no right to stand by counsel.
Why did you not check this box?
Because it is my understanding that representing myself pro per, I can have standby counsel. So that, in a sense, is why that box specifically is not checked.
That is not a correct statement of the law, sir. Standby counsel is not for the benefit of a defendant, it's for the benefit of the court. This court would also not appoint standby counsel in this case. Did you hear me say that?
That's fine.
The court doesn't have to appoint you standby counsel. The court can appoint standby counsel, and courts in Wisconsin have done that. But when they do it, it's for the benefit of the court. So if the court makes the decision that I think this could go more smoothly, if I had a lawyer here who was able to intervene and maybe clarify something or this, that, or the other, I'll appoint this person. It's for the trial judge, not for the defendant. So he has no basis to appeal on that. Now, if he wanted a lawyer, his family could have had a GoFundMe, I guess, and hired one to help him write his stuff or whatever. But of course, what he was asking for was the government to provide him standby counsel, as if the Constitution has a Burger King clause in it and you have it the way you want it. That is not how it is. And it's not a la carte. You don't get to just pick and choose what you want. You run the courtroom, the court there to take your order, sir. Listen, you'd like a lawyer on the side. What else can I get you? That's not how it works. He was told what the ramifications of his choice would be, and he made it a very fair situation by the judge. So I'm sure there'll be, some errors assigned to evidence or something that happened during the progress of the trial. I don't think any of this amounts to a reversal. I do think his change of venue is probably the best argument he has because it was so covered, but I don't think there was evidence that they were out there trying to hang him in the media to such a degree that the judge couldn't get, in this case, 16 people on the panel who hadn't already formulated a decision or impression as to his guilt. That's all she had to do, and that's what she did. Thanks, bye.